partner in the Employee Benefits and Executive Comp Group here at Locke, but I'm located in Providence, Rhode Island, as opposed to Texas. So Phil's in Texas, and so he'll be handling a lot of the Texas aspects of this presentation. So I thought I would start with just an overview. Let's see if I can move it. There we go. An overview of what we're going to talk about today. We'll start with a review of the Dobbs decision and what the Supreme Court held, and then where we are in terms of the current state laws. Then we'll turn to the ERISA implications, particularly ERISA preemption, and finally talk about benefit plan design considerations. So the Dobbs decision. So Dobbs v. Jackson's Women's Health Organization, as you probably know, the Supreme Court decided this case at the very end of its term last June. The decision was released on June 24th. And the facts of this case were centered on a Mississippi law. Mississippi had a law that banned abortions after 15 weeks from conception, except in cases of a medical emergency or fetal abnormality. Mississippi argued that this law was valid not only under the Supreme Court's existing laws, but argued that a reversal of Roe v. Wade and Casey v. Planned Parenthood was essential. So as you know, Roe and Casey are the two key Supreme Court decisions that set out the court's standards for addressing restrictions on abortions. The Roe decision, which was decided in 1973, when the Supreme Court first recognized that the U.S. Constitution protects a woman's right to choose to have an abortion as part of the privacy interest protected by the Due Process Clause of the 14th Amendment. And the Casey decision, which was decided in 1992, where the Supreme Court reaffirmed Roe, that the U.S. Constitution protects a woman's right to choose to have an abortion. Through Roe and Casey, the Supreme Court set out the governing legal standard until the Dobbs decision on when states can restrict abortion. The standard was an undue burden standard, which focused on state regulations up to the point of fetal viability, which is at approximately 24 weeks. Casey held that before that point of fetal viability, a state cannot put an undue burden on a woman's choice to have an abortion. But Mississippi asked to overturn these precedents, and the courts did so, holding 6-3 that the Constitution does not protect a woman's right to choose to have an abortion. I mean, essentially, it was really 5-4 because Chief Justice Roberts basically agreed with the majority that the Mississippi law was valid, but he didn't go as far as overruling Roe and Casey. So essentially, the court, upheld the Mississippi law and overruled the decisions of Roe and Casey, which stood for over almost 50 years. So what does Dobbs do? It returns the power to weigh the arguments in favor or against abortion back to the states. So in the opinion, the court posed three questions in making its decision. The first question was whether the Constitution confers a right to abortion, confers the right to obtain an abortion. After looking closely at the text of the Constitution, the court answered no. Justice Alito, who wrote the majority opinion, wrote that the Constitution never mentions abortion. The second question answered by the court was whether the right to abortion was rooted in the nation's history and tradition, and whether it is an essential component of what the court has described as an ordered liberty. This question centers on whether the right to abortion is part of the substantive rights found in the 14th Amendment's Due Process Clause. So just to remind everyone what the 14th Amendment says, it basically provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor to deny any person who in its jurisdictions the equal protection of laws. So the court spent a lot of time on the state of the law at the time of the enactment of the 14th Amendment, which was in 1868, and concluded that at that time, there was no right to an abortion. The court noted that at that time, basically in 1868, and prior to that, the majority of states prohibited abortion at all stages of pregnancy. As a result of this, the right to abortion is not deeply rooted, wrote Justice Alito, in the nation's traditions and history. The third question posed by the court was whether the right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. The court stated that the right to an abortion did not have a sound basis in precedent. It went through the different cases that, upheld the abortion, particularly Casey, and stated that Casey relied on cases involving other things, like the right to marry a person of a different race, the right to marry while in prison, the right to obtain contraceptives, the right to not to undergo involuntary surgery or forced administration of judges, and substantially similar procedures, but not on abortions decisions. So the court answered no to that third question. So, and as a result of all of that, it overruled Roe and Casey. So now you may be asking, what about the doctrine of stare decisis? Doesn't that apply here? Well, the doctrine of stare decisis means that the Supreme Court essentially sticks with its opinions that it's decided. It doesn't necessarily overrule cases that it has already decided. But in Dobbs, Justice Alito said, the doctrine of stare decisis does not apply here. It does not compel unending adherence to Roe's abuse of judicial authority. He went on to write that Roe was egregiously wrong from the start. Its reasoning exceptionally weak, and the decision has had damaging consequences. So now, with the Dobbs decision and Roe and Casey being overruled, there is a new standard for reviewing laws on abortion. This new standard basically throws out the Roe and Casey viability standard and trimester construct and adopts a rational basis standard. Based on this standard, most state laws regulating abortions will most likely survive. I'd like to take a few minutes now to discuss the concurrences and the dissent because they are somewhat significant. Justice Thomas wrote his own concurring opinion and took a view not shared by the other justices and a more narrow view, advocating for the eradication of all substantive due process rights on the same grounds as Dobbs. Justice Alito said in the opinion, though, that nothing in this opinion should be understood to cast doubts on precedents that need not concern abortion. So he was trying to tamp down a little of what Justice Thomas was saying. Justice Kavanaugh wrote his own concurrence and agreed that Roe was wrongly decided, but defined the issue before the court as what the Constitution says about abortion. He stated that the Constitution is neutral on the issue of abortion. It neither outlaws it nor legalizes it, but leaves the question for the people and their elected officials to decide. Chief Justice Roberts, as I said at the beginning, concurred with the judgment in that the Mississippi law was valid, but he did not concur in overruling Roe and Casey. The dissenting justices, Justice Breyer, Justice Sotomayor, and Justice Kagan, issued a rare joint dissent, and they sharply criticized the majority approach and the heavy reliance on history. Thanks, Phil, for doing the whoops. So what does that leave us? I think that let's see, oh, how come this is not, sorry, I'm having a little, there we go, I'm sorry. So the justices sharply criticized the majority approach. They basically said those responsible for the original Constitution, including the 14th Amendment, did not perceive women as equals, did not recognize women's rights. When the majority says that we must read our foundational charter as viewed at the time of ratification, it consigned women to second-class citizens, and that the exact scope of the coming laws as a result of the decision is a curtailment of women's rights, and that status as a free and equal citizens. And they also talked about it being a very loaded and heavy-handed decision. So now where does that leave us? Now that the Supreme Court has overruled Roe and Casey and essentially thrown back into the states the ability to regulate abortions. I'm going to turn it over to Phil to talk about the current state of the law and where things are now.
Thank you, Lori. So it is expected that probably by the close of 2023 that 26 states are expected to ban or severely restrict abortions. One way this has already occurred is the enactment since 2021 or earlier of what are sometimes referred to as trigger laws, laws that become effective once Roe v. Wade and Casey are overturned. Most state laws that ban abortions provide for some exceptions, but one problem for plan administrators and employers is that there's no consistency. Some only permit abortions in the event there's a medical condition caused by the pregnancy that is life-threatening. Others will add any kind of risk of severe impairment to the health of the pregnant woman. Others, but not all, also provide exceptions in the event of rape or incest. One of the other problematic provisions in the statutes that really impacts employers is the laws prohibiting aiding and abetting the performance or inducement of an abortion, including payment for the abortion through insurance or otherwise. Examples of this are some general statutes, such as the Texas Penal Code that holds a party criminally responsible for aiding and abetting a crime. More specific legislation is expected during the 2023 legislative session in Texas. Another example is Missouri's Right to Life of the Unborn Child Act, which makes knowingly aiding the performance or induction of a non-emergency abortion a Class A misdemeanor. One other development is that it is anticipated that there will be updates to state licensing and board regulations and guidance specific to the new state abortion laws. In some states, the appropriate licensing authorities are specifically directed to revoke the license of physicians, healthcare facilities, pharmacies, telehealth providers, and other healthcare providers who perform, induce, or attempt a prohibited abortion. On the other side of the coin, there are some states that provide for enhanced access to abortion. There are a total of 6. The insurance laws in Oregon, New York, and Illinois require the full cost of an abortion procedure to be covered by the insurance plan. California, Washington, and Maine insurance laws permit the employer or plan to impose a deductible copay or co-insurance payment from the patient.
In the wake of Dobbs, the federal government got involved. Recently, President Biden has issued an executive order at the beginning of July that essentially asked the Department of Health and Human Services, the HHS, to look at how federally governed hospitals would relate to the overruling of Roe and Casey. And so what the HHS did was recently issued guidance to hospitals, advising that the Federal Emergency Medical Treatment and Labor Act, which is EMTALA, applies to patients who present at a hospital emergency department in need of an abortion to address the emergency medical condition. So EMTALA, it's hard for me to say that, was enacted in 1886 and requires hospitals who receive Medicare and Medicaid funding to provide patients who come to an emergency department with an appropriate medical screening examination. If a patient presents to the emergency department as having an emerging medical condition, The hospital then must provide stabilizing treatment within the hospital's capability. As a general matter, the responsibility to determine whether an EMC, emergency medical condition, exists rests with the examining physician or other qualified medical personnel. And EMTALA defines what an emergency medical condition is. The HHS guidance basically seeks to clarify and provide certainty to providers and hospitals around their legal obligations under EMTALA in wake of Dobbs. The guidance emphasizes that state laws that prohibit abortion with no exception for the life and health of the mother, or a narrower exception than contemplated by EMTALA's emergency medical condition definition, are preempted by federal law. Similarly, the guidance notes that any state actions against a physician who provides an abortion in order to stabilize an emergency medical condition for a pregnant woman presenting to the hospital's emergency department likewise would be preempted by EMTALA. Finally, per the guidance, a hospital is precluded from citing conflicting state law or practice as the basis for a transfer. So essentially, such guidance provides that if a physician believes that a pregnant patient presenting at an emergency department, including certain labor and delivery departments, is experiencing an emergency medical condition, and that abortion is the stabilizing treatment, the physician must provide that treatment. So I'm going to turn it over to Phil to talk about the two state court actions challenging this federal guidance.
Right. Thank you, Lori. So the state of Texas filed suit against HHS challenging the EMTALA guidance. And then on August 23rd of this year, the U.S. Federal District Court for the Northern District of Texas issued a preliminary injunction drawing two conclusions. One was that HHS may not enforce its guidance and interpretation that Texas abortion laws are preempted by EMTALA. And then secondly, HHS may not enforce its guidance and interpretation of EMTALA, both as to when an abortion is required and EMTALA's effect on state laws governing abortion within the state of Texas, or against members of the two physician associations opposed to elective abortions that joined in this action. But meanwhile, in Idaho, a federal judge ruled the opposite on August 24th, the very next day, enjoining the enforcement of Idaho's abortion law set to take effect on August 25th. And August 25th was the date on which the Dobbs decision became final. In that decision, the court found that the Idaho law was, which was set to criminalize most abortions, except for limited circumstances, including those where abortion is necessary to prevent the death of a pregnant woman. The ruling held that EMTALA's definition of emergency medical care covers treatment for conditions that place a patient's health in serious jeopardy or risk impairment to bodily functions or of an organ, not just to avoid death, and found that under those circumstances, EMTALA preempted the Idaho abortion law. I would say that both of these cases are under appeal. And since these are in two different circuits, we could very well end up with a conflict among the circuits, which might cause this case to go then to the U.S. Supreme Court. So I think we're on to ERISA preemption, Lori.
Thanks, Phil. Before we start our discussions on the benefit plan considerations, which is next, we need to talk a little bit about ERISA preemption. For those of you not familiar with ERISA, which is the Employee Retirement Income Security Act of 1974, one of the purposes of ERISA was to create a uniform regulatory scheme that applies nationwide to employers regulating their retirement plans and health and welfare benefit plans. So as a result of that purpose, ERISA Section 514 preempts any and all state laws that relate to employee benefit plans as defined under ERISA. Since ERISA was passed in 1974, the Supreme Court has interpreted the relate to provision very expansively, encompassing any state law that affects benefit plan structures or benefit plan administration. So, for example, a state law that makes it illegal for an ERISA covered benefit plan to cover an abortion would most likely be preempted. So that seems good for health plans. But what about fully insured plans where the state where an insurance policy, a state covered insurance policy insures the benefit? Does ERISA preemption apply here? So it doesn't, unfortunately. ERISA does not preempt state laws that regulate insurance, banking, or securities. This is known as the Savings Clause. The Savings Clause allows states to regulate fully insured plans, not directly, but indirectly through the regulation of the insurer and the insurer's contracts. So this means that if your group health plan is insured, so that you buy or your company buys an insurance policy from Blue Cross, or another insurance provider, that plan would not be able to cover or reimburse abortion expenses if the insurance policy is issued in a state that bans or restricts abortions. So what if you have a self-funded plan? So that means that there's no insurance policy, backing the insurance, backing the expenses, and that all of the expenses are paid out of the general assets of the company. So does this savings clause apply to it, those types of plans? And it does not. So a state cannot regulate a self-insured plan. If there's no insurance in the plan, a state really can't regulate it. So ERISA provides that an employee benefit plan shall not be deemed to be an insurance company or other insurer under state laws that purport to regulate insurance companies or insurance contracts. This is referred to as the Deemer Clause. So this means that an employer's self-insured plan will have greater flexibility over whether abortion costs will be covered or reimbursed by the plan, even in states where abortions are banned or restricted. So now I'll turn it back to Phil to discuss his thoughts on whether SB 8 is preempted by ERISA, and then also to discuss the criminal aspects of things.
Sure. So Senate Bill 8, or SB 8 as it's known, authorizes civil actions against individuals who either perform an abortion or aid and abet an abortion, including payment through insurance or otherwise. This is a civil action or civil law. It is not a criminal statute. One of the aspects of this is that the private civil actions can be brought by a third party who has no relationship either to the state or to the patient, and allows collection of not less than $10,000 per abortion performed, plus attorney's fees. And there is significant potential liability here. So the question is, would these laws be preempted by ERISA? My view would be that under existing ERISA preemption case law, it's likely that a court would find that these state civil statutes that restrict the self-insured plan's ability to provide coverage for abortions would be preempted. Now, so far we've talked about how ERISA preempts state laws that relate to employee benefit plans. You've already seen that there was a carve out for insurance regulation, but there's also an exception for generally applicable criminal laws of a state. This carve out was generally intended to prevent a general criminal conduct from being immunized from prosecution simply because it relates to an ERISA plan. One example might be, for instance, a plan trustee who embezzles funds from a pension fund would not be immune from criminal prosecution for that theft. Courts have construed generally applicable criminal laws to mean those that prohibit conduct generally and apply to the entire population. So What about a criminal statute that is specifically directed at employers and or employee benefit plans? We believe that these would likely not be considered as generally applicable and therefore might be subject to ERISA preemption. But that is an area that remains with a good bit of uncertainty, and we'll have to wait and see as matters develop how well protected a plan might be and plan administrator might be from prosecution under those statutes. So a few other points. One is one of the difficulties with the potential for inconsistent regulation of health benefits due to the general applicable criminal laws is there's no consistency in how these statutes read state to state. Many health plans cover abortions on the basis of medical necessity, but this is a different standard than most state statutes that restrict abortions, which normally require it to be either life-threatening or severe medical harm to the pregnant patient. And as discussed above, many states, including Texas, have enacted laws prohibiting aiding and abetting, and it remains to be seen as to whether, to the extent that those would apply to an employee benefit plan, whether those would be considered as generally applicable. A few other comments. There really is no precedent for criminalization of actions that are expressly permitted by the terms of a group health plan. So this is an area of first impression and a great deal of uncertainty as to how the courts will come down on this issue. Some states, of course, do specifically target employers who pay for elective abortions with felony criminal sanctions, and whether these laws will be considered generally applicable still remains an open state-specific question. Nevertheless, most of the 26 states that ban or severely restrict abortion are anticipated to criminalize any violation of their abortion statutes. Additionally, it's likely that criminal statutes relating to aiding and abetting an abortion will be drafted in an effort to be generally applicable so as not to be preempted by ERISA, but will obviously be subject to challenges in the courts. The number of questions regarding the Texas abortion laws. Texas Health and Safety Code Section 170A is an attempt to limit the ability to perform an abortion except in certain circumstances. And of course, it creates a potential private cause of action. There are a number of potential constitutional changes, one of which is the Commerce Clause, the other the Dormant Commerce Clause, which essentially is intended to prevent the free flow of commerce and travel. In Justice Brett Kavanaugh's concurring opinion in the Dobbs decision, he made reference to a travel ban that a travel ban would fail on constitutional right to interstate travel. And we are aware that at least some states, including Texas, are considering passing legislation that would prohibit a resident of the state of Texas from traveling to another state to have an abortion. That probably would fall within the interstate travel right, which would at least have some support by Justice Brett Kavanaugh, who's now considered to be the swing vote in the Supreme Court. There has been comments by the U.S. Attorney General, Merrick Garland, regarding the right to reproductive care, as he expressed it. So we anticipate that there will be other potential challenges. So a few other comments. There is precedent for arguments that state laws that otherwise expose employers to liability are unconstitutional and should not be applied to out-of-state travel or related benefits. One of the issues in that instance is that there is at least some argument that this issue of interjurisdictional prosecution could be subject to challenge in the current makeup of the Supreme Court. For instance, one of the decisions that was cited by Justice Kavanaugh was Bigelow v. Nixon, which is Bigelow v. Virginia, and it related to a cross-border criminal prosecution between a Virginia newspaper editor and the state of Virginia. The publisher of the Virginia newspaper had run an advertisement advertising abortions in New York. Subsequently, he was prosecuted under Virginia's statute prohibiting the circulation of any publication encouraging or prompting the procurement of abortion. And while the decision was decided on First Amendment grounds, Justice Blackmun, writing on behalf of an 8-to-1 majority, stated that with respect to cross-border issues, that the Virginia legislature could not prevent its residents from traveling to New York to obtain abortion services or prosecute them for going there. Now, that doesn't specifically apply to individuals aiding and abetting, but it is some indication of that. There's also a Missouri Supreme Court case, Planned Parenthood of Kansas v. Nixon, in which the Missouri Supreme Court in 2007 concluded that, and again relying on Bigelow, that states could not legislate their citizens' behavior when they travel to another state. And the court cited, among others, the Commerce Clause, the Due Process Clause, and the Privileges and Immunities Clause in the Constitution, along with the general right to travel. And so those are aspects that would likely give rise to potential defenses against some of the efforts on the part of the states to criminalize what otherwise would be permissible under the terms of an employee benefit plan. So I think, Lori, I believe that it's now to you on benefit considerations.
Now we're going to turn to the benefit plan considerations. So the first thing that you should do from an employer's perspective is really to assess your medical plan. You should determine where your employees are, what states that they're in, what the laws of those states are, now, and what does your plan cover. So many of our clients really don't know the nuances of what their group health plan covers. So you should determine whether you're self-insured or fully insured, because as we talked about before, fully insured plans, because of the insurance aspect of them, will have a harder time covering abortion costs in states where abortion is banned or restricted. You need to determine whether your plan covers abortion services, whether they cover just elective abortion services or non-elective. From a tax code perspective, any abortion, elective or non-elective, is considered medical care and will be covered by a group health plan unless it's specifically excluded. Does the plan cover services that are legal in the state where the employee resides? Does the plan cover pharmaceutical contraceptives like Plan B that prevents someone from getting pregnant? And does the plan cover the abortifacient drugs, the drugs that will cause a woman to have an abortion? So you have to understand what the coverage is under the plan, and then decide what the employer wants to offer. With respect to the pharmaceuticals and the drugs, it's really important that the employer talk with their PBM, their pharmacy benefit manager, to see what restrictions they may be under and what they may be willing to provide in the area of abortion drugs and coverage. The employee should also start talking to their third-party administrator. I mean, particularly if they're a self-insured plan, to really see what the third-party administrator can do with respect to abortion services. You want to look at whether the plan offers any telehealth benefits. This may become a concern if a telehealth provider can prescribe an abortion drug to a person in a state that bans or restricts abortions. So this can cause some issues. So you need to understand again what the plan provides.
Lori, I would just add there as to telehealth, more and more states are requiring that telehealth providers be licensed in the state in which the patient is located. And so even though that individual might not reside, or the telehealth professional might not reside in the state in which the patient resides, he or she may be subject to licensing requirements in that state, which may also impair their ability to provide or prescribe such medications.
Right, that's a good point, Phil. You should also look to see if the plan covers travel benefits. Group health plans generally have travel benefits for travel to centers of excellence for treatment or travel for organs transplants. That essentially then, if someone has to travel, to another healthcare facility for an organ transplant that's out of their state, that the plan would cover both the organ transplant and the expenses associated with that, and also with any travel and lodging expenses associated with getting their care. So, as I said, you really need to understand what the plan provides, and then you need to look at what it is that the employer wants to do. As to whether the employer wants to provide, abortion services and cover, any sort of expenses associated with abortion services or travel associated with the abortion services or not. If a majority of your employees are in a state where abortion is protected, then you may not need to do anything with respect to your plan. But if you're in a state that restricts or bans abortions, and you want to provide some benefits to your employees, then you'll need to figure out what it is the plan provides and act accordingly. So if you want to provide some sort of abortion benefit, you need to think about how to structure it. The one that has been written about most often, and the one that a lot of employers are talking about, are these travel reimbursement benefits. So now you need to figure out how you're going to structure that. So, if you have a self-insured plan, that basically can provide access to abortion services and cover them, that has a travel benefit, you may just be able to do it through that plan and essentially perhaps amending or expanding the existing travel benefit to cover abortion services. If you do that, you need to talk to your TPA to make sure that the TPA can administer that expanded travel benefit. And if it's within this self-funded plan, ERISA will apply so that you can maintain the ERISA preemption argument. And if it's again within your, your already established group health plan, you don't have to worry about HIPAA because HIPAA will already apply. So the privacy protections will be in place. You don't have to worry about any of the ACA market reforms because the group health plan already satisfies that. You don't have to worry about COBRA. You don't have to worry about, mainly all of the federal laws that apply to group health plans that would regulate them under the federal law. Some things that you need to think about, in the travel benefit within the plan, and even outside of the plan, is whether you would want to limit the reimbursement to what is excluded under the tax code, which I will talk about in a few minutes, and then whether to have a overall monetary limit on how much can be reimbursed within the plan. Again, so within the existing medical plan, that limits to employees that are in their dependents that are enrolled in the group health plan. So that if an employee isn't enrolled in the group health plan, then they won't have access, at least not through that employer's plan, to any coverage for abortion or reimbursement for abortion travel expenses. So what happens if you want to provide it outside of your plan? The first thing you have to think about is, whether you are creating an ERISA welfare plan or a group health plan for other purposes, including the Affordable Care Act and HIPAA and COBRA, and the Mental Health Parity Act, Mental Health Parity and Addiction Equity Act. Sorry about that. So if the arrangement is structured to provide reimbursements that are considered medical care and travel and lodging expenses that are used to seek medical care are considered medical expenses, the arrangement will be considered a group health plan and an ERISA health plan, an ERISA welfare plan for the ACA, HIPAA, and other state and other federal laws that regulate group health plans. So that's one of the big things that you have to think about, because if you're going to create this separate arrangement that's not integrated or any way coordinated with your group health plan, it's going to fail on the ACA market reforms, which essentially require the coverage of preventative care without cost sharing and prohibit lifetime and annual dollar limits for certain benefits. So again, if you're going to create this sort of standalone reimbursement policy that's going to, pay for, reimburse for medical care, you're going to end up, you could face significant penalties under the ACA if you don't structure it appropriately. So again, if you can't include it within the employer's existing group health plan, the employer can structure the travel reimbursement benefit as a health reimbursement arrangement. There are two types of HRAs that can be used. One is an integrated HRA that's basically integrated with the employer's group health plan, so sort of coordinated with it. So then it complies with the ACA's market reform. Again, it's an ERISA plan, so it would have the benefit of the ERISA preemption argument. It would be, HIPAA would be applied to it so that the employees would feel comfortable that their medical information is protected, that it's private and it's protected under HIPAA. But with an integrated HRA, the employees that would be able to benefit from it would be those that are enrolled in the employer's group health plan. The employees and their dependents that are enrolled in the employees group health plan. So that somewhat limits, the population of employees that may benefit from the HRA. The other HRA is an accepted benefit HRA, which is not subject to the ACA's market reform because it's considered an accepted benefit. Under the accepted HRA, you must cap reimbursements at $1,800 per calendar year. So that's significantly less than what you could do otherwise. And it must be offered with the group health plan, but the employees under an accepted benefit plan do not have to enroll in the group health plan to be eligible for coverage. So this, even though it's lesser amounts that can be reimbursed, it could cover a wider population. And again, both of these HRAs would be considered an ERISA welfare plan, and that would preserve ERISA preemption arguments. Another consideration, another way to structure the travel reimbursement arrangement is through the employee assistance plan. In this case, the benefit can be offered to all employees and their dependents, regardless of the participation in the group health plan. And even if the EAP provides, because the EAP is considered an accepted benefit under the ACA. So even if the EAP provides some medical care, it can be an accepted benefit for ACA purposes and shouldn't affect, and it shouldn't be subject to the ACA market reforms. In order to be an accepted benefit, the EAP cannot provide significant benefits in the nature of medical care. There isn't a lot of guidance out there on what constitutes significant benefits in the nature of medical care. And the employer needs to look at sort of all the benefits that are offered under the plan to determine whether the medical benefits that are being provided under the EAP are considered significant or not. The other requirements to be considered an accepted benefit are fairly easy to comply with. It can't be coordinated with benefits under a group health plan. You can't require the employee to pay a premium or other contribution as a condition to participation, and you can't require any cost sharing for services. So this is the EAP is something that's being talked about a lot. You again need to talk with your EAP provider to see if they're willing to administer the abortion travel benefit, and whether they're willing to do that. You could also basically not do anything and allow the flexible spending accounts that you have, the healthcare reimbursement plan, to reimburse people for medical expenses for abortion travel. But again, there's limits on that, as to how much the flexible spending account can reimburse, and the employee may be wanting to use that for different things and not necessarily for these travel expenses. You also could structure it as a total taxable benefit. So a lot of employers think that, okay, it's totally taxable, not subject to ERISA, so it's not going to be considered a group health plan. But that's one thing you really need to think about whenever you're going to start structuring any type of program that's going to reimburse somebody for medical expenses. That you're not, again, creating an ERISA welfare plan or a group health plan that would be subject to the ACA and the other federal laws that I spoke about earlier. So we're not seeing a lot of employers using the taxable reimbursement arrangements. They pose significant risks, perhaps, to the employer. It probably will be more costly for the employer to do this. There's a lot of privacy concerns about employer having access to the employee's private information, and most likely ERISA preemption may not be available in this situation, particularly if the plan is not considered an ERISA welfare plan, and it's basically like a stipend where you give all of your employees, say, $1,000, to use for travel for whatever reason that they want to. And just submit a receipt that they went somewhere and not necessarily the reason why they traveled.
Lori, it seems to me that the ERISA preemption issue is one that employers really need to be careful to be able to avail themselves of, certainly with respect to any type of civil statute that in any way restricts an employee benefit plan from being able to reimburse for an abortion procedure. But secondly, there is always the potential defense that even a criminal statute may be found to not be generally applicable and therefore is also preempted. And so I think that most employers are inclined to want to have a program that is considered to be an ERISA health and welfare benefit plan in order to minimize their exposure under state civil law in particular, but also potentially protection under state criminal law as well.
Right. No, that's a great point. So if you decide to implement a travel reimbursement program, one of the key considerations is how this benefit will be taxed. So under 213 of the code, section 213 provides that amounts paid for travel, including transportation primarily for and essential to medical care, is considered medical care and can be deductible by the employee and not included in the employee's income if paid by the employer. So here, the critical issue is that the transportation and lodging must be primarily for and essential to the medical care. So the IRS guidance makes clear that you cannot deduct or get tax-free. An employee can't deduct or get tax-free a vacation or a trip for their health, even if the doctor told them that they needed to go and take a vacation. So as you see on the slide, the mileage here is only 22 cents a mile, which is significantly less than the standard mileage for business travel. Tax-free reimbursements for lodging are limited to $50 a night, which increases to $100, so $50 per person if the individual is traveling with a caregiver. Reimbursements for meals and incidental expenses are not are fully taxable and included within the employee's income if the employer is reimbursing them for it. State laws may be different, so that's just one thing that the employee needs to think about when they're doing this. So that it's not a significant benefit, to be taxable, but at least it's something if the employer wants to provide some sort of tax-free benefit for travel for abortion services. So we talked about these other benefit considerations. We talked about a lot of these, the ACA, COBRA, and HIPAA. One thing to really think about is if you have a high deductible health plan with a health savings account. A high deductible health plan is a type of medical plan that has a high minimum deductible for medical expenses that must be paid before the insurance piece of it kicks in. So with travel reimbursement, you can't reimburse for travel expenses, for these medical care expenses, before the deductible is met for a high deductible health plan, or the individual will lose their ability to contribute to the health savings account. So that's just one thing. If you are structuring a travel reimbursement outside of your traditional, health insurance plan, that you need to provide whoever is administering that travel benefit with information on those people who are in the high deductible plan, just to make sure that you're not going to trip this provision and reimburse them or provide them with any benefits before they satisfy their deductible under the high deductible health plan. But on the sort of the flip side of that is that if the employee can use funds in their HSA to reimburse themselves for travel expenses in the event that they have to travel to get an abortion. So that's really all I had with respect to benefit plan considerations. And I know that we're sort of at the top of the hour a little bit, but I don't know, Phil, if you wanted to add anything, on this.
Sure. It seems to me that there are two or three things that are going to be of significant importance as we move forward in this area. One of which is the degree to which states can be successful in prosecuting employers for paying for an abortion in a state in which that abortion is legal under the aiding and abetting provisions. I think the other is the extent to which these criminal laws will be actively enforced. It's interesting that, for example, in Texas, there are several district attorneys who have already declared that they will not enforce any or prosecute under any criminal statute banning abortions, although other district attorneys have indicated a willingness to prosecute cases in those states. And so there's actually proposed legislation to permit a district attorney in one county to bring a criminal action against a party in a neighboring county or any county within the state if the district attorney in that particular county doesn't choose to prosecute. So we're in a number of areas of great uncertainty, and for employers with employees in multiple states, a great deal of concern about the lack of consistency in these state laws and the difficulty that will come in trying to comply to the extent that you choose to do so. Or any other thoughts on your part?
No, I mean, one thing too, just in terms of, going back to like reviewing your medical plan, one of the other things that you need to look at too is really, who the administrator and fiduciary is with respect to the plan. A lot of plans basically designate the employer as the plan sponsor, the plan fiduciary, the capital P, capital A administrator, for ERISA purposes. And this generally, if it's just the employer, if you look to the company's bylaws, that would then mean it's the board of directors that is, responsible for administering these plans. So you just want to, sort of make sure you know who the resulting or the reporting parties are, because you may not necessarily want to have your board of directors in the crosshairs of some really aggressive, district attorney in Texas or, any other state sort of going after someone. And then also you need to look at your fiduciary liability policy, insurance policy, because there's a lot of carve outs, or there should be a carve out in your fiduciary liability policy with respect to illegal acts, and whether, your plan reimbursing for abortion services, would be considered an illegal act. And if anybody sues for breach of fiduciary responsibility, whether that would be covered under the fiduciary liability insurance policy or not. It's just sort of something to think about. And, I don't know if then more riders will come on the fiduciary liability policy in order to cover things like this. So I don't know if you have any thoughts on that, Phil.
Yeah, Lori, one further thought, though, is it's not unusual to see in third-party service agreements an indemnification by the employer of that third-party service provider for following the terms of their agreement or the plan or specific directions from the employer. And that could result in much more expensive indemnification costs if there were either private causes of action brought against those contract providers or service providers or potential criminal action.
So I think that's all we have for today. We thank everybody for attending.
We do.
If you have any questions, I didn't see any come up on the chat or in the Q&A, but if you have any, our phone numbers and our email addresses are here, so feel free to email us, and I'm going to turn it back to Susan.